I think we've had a fantastic set of 5 expositions really covering this field and the many other aspects that are around this field of strategic litigation. We've got around 35 minutes now for questions, and then we'll break, and there's more time for people to spend together with drinks at the back. So I'll take clusters of 3 questions or short comments. If you're going to make a comment, keep it to about a minute if you would. We have some roving mics, and please, first question here.
Thanks. Claire Parkman from Focus on Labour Exploitation Flex. I have actually 2 questions and 1 comment, if I could be so cheeky. The first comment is more of a spruik, actually, for our Labour Exploitation Accountability Hub. As Nick mentioned, one of the key elements of strategic litigation is an understanding of national law and legal frameworks. And at Flex, we've sought to do that by gathering together a database of legal mechanisms in currently 10 countries, but due to expand to 14 countries worldwide, that includes laws and regulations and policies that can be used to hold companies especially accountable for labour exploitation in a wide range of labour sectors. So that's online if you search Accountability Hub, that's useful. My questions are one for Roger and one for Kevin Hyland. Roger, the cases that you mentioned that were being taken using the TVPRA and the statistics that you gave, I just wasn't clear whether those cases were all taken on the basis of a financial benefit or whether they were direct perpetrators. And also, as I understand it, the TVPRA now has extraterritorial application in relation to the civil remedies. And I wondered whether any cases had been taken using that extraterritorial application and whether there'd been any success or challenges in that. And then for Kevin Hyland, I wondered whether you had or would be making an assessment of the current support that's available to victims in the UK system for victims to enable them to take strategic litigation or litigation straight out against their perpetrators, whether that be the provision of information, the provision of legal advice and assistance, and also the availability of discretionary leave based on compensation and the extent to which that was being granted, and also the gaps that are currently failing victims in terms of assisting them to take that litigation.
Thank you. Great. I've got one of the back first, and I'll come straight down. If you just introduce yourself, sorry, I forgot to say that.
Hi, Laura Fletcher. This question is for Shanta. You made very clear that value is not a target in the litigation you're pursuing, but how feasible would it be to target financial actors such as insurers or investors for strategic litigation in this case or in some business and human rights cases more broadly?
Thank you.
Thank you. I'm Amelia Knott from 2050. We're one of the consultancies working with clients on modern slavery, hopefully one of the good ones. I just had a question really about possible unintended consequences of strategic litigation. I was in Germany recently and in a room full of 100 businesses, and a German lawyer basically recommended that it was lower risk not to disclose than to disclose and risk litigation in the US. And that was the message that all these businesses took away. I've also heard other businesses saying, well, let's not go looking for things because if we know about it, we're going to have to do something around it. And actually the Human Trafficking Victims Protection Act that Roger mentioned said that if you can be sued if you are a knowing beneficiary. And that is there a chance then that this discourages companies from actually going looking, from following the UN guiding principles of knowing and showing, and from actively trying to address some of the risks?
Thanks very much. Great. So we've got 3 sets of questions. The first one was to, I think, yourself, Roger?
Yep. So, to Claire's question, yeah, it is extraterritorial. With respect to who the plaintiffs are, I think you're right, that not all of those that are bringing the cases are against defendants who are financial beneficiaries. In some cases, it might be the actual perpetrators, right? So you're absolutely right about that. There is a really good student note that I'll recommend to you that just came out in the Vanderbilt Law Review, 69 Vanderbilt Law Review, page 499, and it has a sort of a breakdown of the, and according to that student note, there's 25 cases against those who have been financial beneficiaries of that. So it is a smaller subset, absolutely right about that. The only thing I would tweak on your comment, it's not just, it's known or should have known, right? So if other companies are disclosing supply chains from, Thai prawn fishermen, then, and they don't disclose it, then one could say that they should have known, because it's the same supplier for, Walmart and for Costco. So if Costco discloses and Walmart doesn't, the same suppliers from Thailand, they should have known, right?
That's great, thank you. We're going to, should we just stay with that question now? So are there any other people who want to just come in on the unintended consequences issue, which I think is a profound? Nick, did you want to?
Yeah, look, it's always a challenge in the space, and I suspect corporates often want to kind of highlight the risks of unwillingness to be open because of the threat of litigation. But the fact is we're not seeing much compliance or disclosure about honest labour risk full stop. So it's not as though we can kind of go from an environment of disclosure to an environment of no disclosure. I suspect there will be a burden. The other point that I think kind of was nicely highlighted by Danielle in her presentation is that there is an increasing regulatory burden. If you're a US corporation that operates worldwide, you have to comply with California legislation, you have to comply with British legislation. If you supply to the US government, you have to comply with the executive order. There will be the EU requirements. And so there is an increasing burden. I think corporates have to get ahead of it, not just kind of say it's best that we stick our head in the sand. And finally, coming back to this issue that litigation doesn't operate in a vacuum, we're seeing an explosion of investigative journalism around this space. There's been amazing work done on the Thai seafood chain by the New York Times, by AP, by The Guardian, which are naming companies that wittingly or unwittingly, and it's coming out and talking about Nestle, Tesco's, Carrefour, Costco, and others, and they're documenting bills of lading, and they're establishing a kind of a whole transactional chain that means that companies can't turn away from it. The Guardian did magnificent work in Qatar around these issues, and so I think also that makes it increasingly difficult to talk about unknowing, when in fact you should be on notice that there are these risks. And even in places that we're very focused on, like India, where there is a challenge because a lot of the issues around supply chains are internal and not international, and so don't bring in this. Organisations are supporting journalists there to talk about slavery stories. These are powerful stories, so there's a whole incentive for journalism and investigative reporting to talk about all of this that will change, I think, some of the environments in which good corporates are operating.
Any others? Please.
I was just going to echo very much what Nika said. This issue about whether or not companies will suddenly stop actually doing a whole lot of reporting that they're doing because they think those reports are going to be used for litigation has actually been something that's been raised since the entire sort of business and human rights due diligence issue sort of was first pronounced. Like some companies were saying, oh no, well we better not because actually that could form the basis for litigation. But actually if you look at the litigation, a lot of the time it is actually on the basis of it, and we use the kind of general tort principles here, that the company knew or ought to have known that there was a risk of the issue that ultimately occurred. And we would use, for example, whether it's articles from the New York Times or the Guardian or reports by NGOs and so on, to demonstrate that there was that ability to know and that a potential defendant ought to have known. So simply failing to report it is not going to be much of a protection.
Can I just add one small additional comment? I think there's also going to be a movement, in light of these disclosure requirements, a movement toward better labeling procedures. So I think, like in the carpet and textile industries, there should be a movement toward good weave and rug mark in a greater directions, because that's sort of been certified as already slave-free, right? And so why would you not buy a good weave or rug mark type carpet rather than one that wasn't certified by that. So that's one. And the other thing I think that one should look at that I don't think the human trafficking community is looking at is food safety, and just how unbelievably good the supply chain controls are on food safety, because we want to be really, really careful about the way the supply of things that we ingest. And why is it that companies, these exact same companies, can do such a good job on food safety supply chains, but they don't do the same good job on things like forced labor?
Thank you. We have a question to Kevin. Kevin, yours was about the assessment and support on litigation.
Just one point on what was said before. What also needs to be understood is under the Modern Slavery Act, the criminal offence is determined as knows or ought to know. And one thing I've said to prosecutors is the supply chain statements, the slavery statements, will give you some evidence about what they know or ought to know. And I'm looking forward to the first case that is using the supply chain transparency statement as what they ought to have known. And there has already been a successful conviction of a director of a company, Cozy Beds, that was manufacturing beds for Next and John Lewis, and went to prison last month. So there is a focus on this, and it may be that there's criminal outcomes as well as civil litigation. And then, of course, under the Modern Slavery Act, any monies taken off those companies can then be given as reparation to the victims. So I think there needs to be very clever thoughts by prosecutors and those who are lawyers about how well the legislation can be used and how the civil side of it does actually feed into sometimes the criminal side. But answering Claire's question, in brief, yes, we've already undertaken a great deal of work, particularly around the EU nationals who fall off the list once they are end their period in the national referral mechanisms, as I said, and then aren't entitled to any support, which actually then stops them either staying in the country or actually stops them pursuing the criminals, or stops them getting some sort of recompense either through civil litigation or even criminal injuries compensation. So we've made recommendations on that, and that's something that I've brought to the attention of the government, and I need to see some change in that. But I'm actually looking at discretionary leave to remain. Yes, it does apply. It can apply even with EU nationals, but I want to see it used more regularly. I want to see it more effective. I want to see all the partners who should know about it, because it is actually the statutory agencies who should introduce someone to that, not left until the victim could potentially walk across the path of a lawyer. It should be part of the process. So I'm looking at all those gaps. We've looked initially at the EU nationals because of the vast majority who weren't being supported. Now we're looking at sort of NAS accommodation and those places where vulnerability occurs, including the very issues you mentioned about discretionary leave to remain and the overall support to victims. Because obviously I want more victims to come forward, I want more prosecutions, and I want more victims to feel that they're being properly supported. So yeah, exactly what you mentioned are exactly the things we're doing.
Thank you. And Shanta, there was the question about financial actors.
Yeah, I think one of the reasons I mentioned Aviva was not necessarily to talk about strategic litigation against them, but actually to talk about it in the context of if we're saying that actually it's really important for business to engage in this issue and for business to work alongside civil society and the state in order to combat modern slavery, I think we need to distinguish between PR and actual change within the way in which businesses operate. And so, for example, Danielle mentioned that there were 21 investor companies that wrote an open letter to the government prior to the introduction of the Modern Slavery Act, and that was actually very important to sort of put forward a business case for why the publication of these statements was a positive step. And that's great. Aviva was one of them. But at the moment, none of those 21 investors has yet published a modern slavery statement. Now, maybe they just haven't got around to it yet. But I think there needs to be a difference between sort of saying on the one hand something and acting, in a very distinct way, and that should be called out when that occurs. So if a company is going to portray itself as being very pro-combating modern slavery, it needs to look at the way in which it operates and the way in which not only its supply chain, but its actual business operates. In terms of the potential to bring strategic litigation against financial backers, it would entirely depend on the facts of the case. There is a possibility of it. It would depend on to what extent that financial backer was actually able to really influence what ultimately happened. I wouldn't say that that's necessarily the case in the circumstances of an insurer stepping in at the point of litigation that's occurring around something that's already occurred. But perhaps the way in which that litigation is run should be consistent with principles of respect for human rights and concern for issues of trafficking and modern slavery.
I might just follow up on that, not so much on strategic litigation, but I think this issue of supply chains and forced labour is increasingly going to be of interest to insurers because there are insurance risks around this. If your insurer patents, then you want to be cognizant of the fact that you have a big payout on the litigation costs. It is in the US increasingly of interest to activist investors. Pension funds have influence through their choices, and the state pension fund in Norway is very focused on labour rights issues. We put out a couple of reports looking at the whole issue of the linkages between transnational migration, corruption, and human trafficking. If you are bringing workers from Nepal or India into Qatar, then there is a very high chance, and often they end up in bonded labour in Qatar, and bribes will be paid at every stage of the process. And companies might not be that concerned about modern slavery liability and extraterritorial jurisdiction of TVPA. They are very concerned if they're US companies about the Foreign Corrupt Practices Act and bribery prosecutions and Bribery Act prosecutions here. So all of these things start getting linked, and I think that it's not just about compliance statements, important though they are, but it's an understanding that the whole kind of business environment around these issues is changing in really important ways.
Thank you. I'm going to move back to questions. So another cluster of three. I've got a question there, please.
Thank you very much. My name is Lynn Evans. I chair a committee on standards and human rights in the security industry. And we look at all these issues very carefully. What worries me about what I'm hearing is that it's presentations by lawyers or other lawyers. As Danielle probably found when she was looking at websites, you have on the websites statements that were written by lawyers just in case they end up in court. They can demonstrate in those statements what it is they have done to comply with whatever the legislative requirement is or the compliance requirement. If you want to change behavior, which is what we want to achieve here, you have to get at the managers. You have to have a sense of accountability and corporate responsibility that goes right down through the company, through the supply chain to the lowest possible level. I can mention an industry where we have actually done that on the basis of voluntary standards and audit. But I wonder how you, the panel, see getting this message across where it really matters, which is more than board and legal counsel. Thank you.
Thank you. Other questions? Please, two more. One in front and one just behind.
Hi there, I'm Ben, a memoir barrister. I just wanted to go back to this criminal versus civil distinction because personally I think that in the context of trafficking and modern slavery, it's a massive distinction, particularly when you think about the whole issue from the point of view of the victim. Obviously there are going to be pros and cons either way, but victims typically being vulnerable and potentially damaged in a variety of ways. One can see how approaching a prosecuting authority and the higher standard of proof that would apply in criminal proceedings might be off-putting in some ways, and the flexibility of civil proceedings might offer some advantages potentially. And on the civil remedies point, I just wanted to ask Shanta about the Houghton's case, because I was wondering when I was listening to the facts and the procedure of the case, whether they're arguing illegality as defence, and if so, what type of fancy footwork you might be doing around that issue.
Thank you. And there was another question just immediately behind.
Oh, hi, thank you. My name is Elizabeth Acorn. I'm a PhD student. I actually had a very similar question about the considerations of civil versus criminal liability, but more from a perspective of maybe justice and accountability, and what are the trade-offs we might think about in the types of civil actions that should be pursued. Is the role of a civil action here to try and replicate the sense of justice for the victim? Or is it more of an idea that what we're really looking for is some effort to achieve accountability, regardless of who the plaintiff might be named as or what precise form of action is chosen?
Thanks, that's great. So if we could go back to the panel, there's a set of questions there. Maybe we should start with the first, Glenn Evans' comment around how do we ensure that this issue is taken up more than by lawyers and actually by the management through the organisation. I'd like, if we can, we'll go to a final round of questions, so if we could be fairly brief on these three, that would be great. Who'd like to answer that one? Please.
First of all, yes, I mean that with a lot of the statements that did very much feel how they were written. And you know, I talked about the dangers of the sort of plethora of consultants that are saying to companies, "Oh, we can sort this out for you." And as Kevin said, what it actually needs is wholesale change within companies, and that you know, that is going to be difficult to achieve. On the one hand, there is the obligation in the Act for it to be signed by a director, and I do think that that is important, even though I take the point about it. It's important to cascade it through the management of the company, but a director does need to think very carefully before they're going to sign off a statement that is potentially misleading. We've heard about how, you know, an interaction with consumer protection law could lead to possible actions if a statement is, for instance, deliberately misleading. You know, we've talked as well about the standards that we have. You know, we have very much stricter standards in terms of food safety than we do about the conditions that the goods are made in. And I think in many ways until we move to those kind of stricter standards, there will be the difficulty of with unwilling companies of getting them to really take the matter seriously and embed it deep within the company. But as well as the stick, there's the carrot. There's lots of other things that we're looking at the Resource Centre and know the chain in terms of benchmarking companies, so encouraging a race to the top as well and demonstrating best practice. So there are sort of many other avenues that we can explore to apply pressure to companies and get them to change the behaviour in the way that we want them to.
Thank you. Well, Kevin, do you want the name?
Sure. Very quickly, I think what Glenn raises is very right, but I think that the fact that this has to be signed off at board level is essential, and that's what needs to be managed and observed, because if they're not compliant with the Modern Slavery Act, then the Secretary of State can ask for an injunction to make sure they are just compliant. But there's also, and this week or next week you will see that at Chelsea Flower Show, for example, there is a modern slavery garden, and that's going to launch a consumer-led campaign, which is going to be hashtag Ask the Question, because what they want to do is to get the consumers asking the question, photographing goods, photographing and sending it off and asking the question of directors and managers, is this actually legitimate? Some of you may have seen the Al Jazeera programme where there were cars being washed again in Kent for Volvo and Kia. When that happened, people were in slavery, losing fingers, being kept as like animals, or worse than animals, not being paid. I wrote to the CEOs of Volvo and of Kia. Volvo took immediate action and have inspected all their dealerships in the UK. Kia have been less quick about responding, and I will chase that up. But there will be some public shaming that will come, and that will actually stop people buying goods. So actually it's this consumer-led. We need it to be judged by the consumer, the shareholder and the investor. But actually once people say we're not going to put up with it and we're not going to buy it, that's when we will get the change. And I think we've got the opportunity with the drive and the modern slavery and keep the agenda going, that we can actually force companies in the UK who trade in the UK to make that change. And recently when Nick and I were in Singapore, we see that British companies there are keen to drive that forward. So I think at the stage it not being punitive and it being the sort of rise to the top as opposed to dive to the bottom is the right model. maybe in years to come, it may need to be punitive once we've got a level playing field.
So I'm just going to combine the three questions into a few remarks. One, I mean, civil and criminal law are both should be used as leverages so that corporations become accident avoiders, right? I mean, you just take basic law and economics. The goal of tort law, the goal of criminal law is so that good behavior is encouraged and bad behavior is discouraged. And so if there are sufficient incentives through threats of prosecution, threats of criminal imprisonment, threats of civil, remedies, all of those encourage corporations to be an accident avoider. And that's, I think, all to be welcomed. I didn't have time to talk about it, but in the notes, the Sudanese genocide case, BNP was first prosecuted criminally, and then after the prosecution and the payment of a multi-billion-dollar fine, then they're now being sued by the victims. So it goes in different directions, but certainly that's a follow-on civil case after it's criminal. In terms of getting the actual officers in the company to care about it, I think the bribery context is a good analogy. It started in 1979, and it took 25 years before it started to be taken seriously by many companies. But now, every company worth its salt has sort of monitoring mechanisms for making sure there's not corruption in the supply chain. And so it's basically workplace sexual harassment guidelines, workplace bribery guidelines. Eventually we'll have similar things for this.
I'm personally an advocate of having legal standards and not just voluntary standards. It does seem to me that having legal standards that are required to be adhered to, at the very least, focuses the minds of many companies. And that includes not just the lawyers in those companies, but actually they will make sure that the managers are responding if they are going to be otherwise penalised by something. I just want to quickly touch on this criminal and civil. The two questions were interrelated, but in terms of civil versus criminal, I think a lot of the time what would be desirable is not that it has to be one or the other, but perhaps that both are pursued in the sense that the criminal action will hopefully ensure that those who are the perpetrators are actually brought to justice, and so there is that criminal element to it. But there's often not enough of a focus on, well, what was the situation for the victims, to what extent do they actually get put back in the place that they would have been if none of this had happened, and obviously that's where civil compensation can play a real role. In the Houghton's case in particular, it just happens to be that unfortunately, despite many years of these particular clients being very willing to talk to the police, despite there being an investigation, there simply hasn't been a prosecution, and they were quite frankly at their wits' end. And at the very least, there is a chance now for them to actually air their grievances and have them determined in court, and hopefully obtain compensation that will assist them to move on with their lives.
Thank you.
On a standards point, I'm actually quite optimistic in this space. I mean, I kind of see that we're moving from the very initial disclosure, which is going to be legalistic, but we also see big corporations really grappling with this issue about what they need to do. And it's not just going to be around the Modern Slavery Act. It's things like Rana Plaza. It's things. Supply chains have been stretched, I think, beyond reasonable limit, and companies are understanding that in fact that poses real risk for them. So they're grappling. A very big company, Walmart, where it has tens of thousands of supply chains, are willing now to put someone on stage, and not their CSR person and not their legal counsel, but their procurement and sustainability person is going on stage talking about what they're doing, which I see as a huge advance, because they realise that they actually have to get to grips with the substance of these issues. So I see the initial round of statements as just the beginning of a process of education, and hopefully that we'll get into deeper. We launched our corruption reports with the Chartered Institute of Procurement and Supply. They're interested and they represent procurement officials because they understand they have to get around on top of this issue. And on the civil criminal stuff, we had a 2-day convening last week in New York around strategic litigation. We had a lawyer from the Southern Poverty Law Center that was talking about an amazing US case called Signal, where a US corporation, a major corporation, engineering corporation, imported workers from India, locked them up, exploited them, and you just don't expect this to happen so blatantly. I mean, I'm still struck, and I work in this space, at the blatantness of this conduct. And when you get into a civil case, you get into magnificent discovery, which unearths all sorts of things. And they got a judgment for a very small group of Indian workers who got a $14 million judgment with about 200 or 300 workers queuing up to kind of bring this case. So this corporation actually went into bankruptcy with a protected payment of $20 million for workers. So, a reasonably good outcome, but probably a very strong signal and one of the powers of civil litigation. But the other striking fact was that the authorities were not willing to bring criminal cases in the US, so this was the only option. But a pretty powerful one in the end.
Thank you. So we've got about 6 minutes left. I've got two final questions. One at the back then, and there was, all right, three then, but that's it. Thank you. Sorry.
Thank you. Hi there. My name is Kuzenko. I work in the investment industry. I work with a UK pension fund. In our listed equity portfolio, we've got maybe 3,500 companies, and in the private equity portfolio, several hundred, I was remaining. If we are going to take on the challenge that's been placed at our door earlier of contributing to the eradication of modern slavery, then we need tools that can help us really get a grip on how best to go about identifying and prioritising our investigations when you've got that kind of set in front of you. So I was wondering if any of the panel might be able to comment on how might you think of structuring an investigation around this in this kind of a context. I mean, are there particular markets where access to law is particularly weak, where the law itself is particularly weak, and where, for the sake of argument, major UK companies do seem to be deriving significant revenues, because that's where a UK-based pension fund is going to have its trustees are going to find greatest resonance with UK listed enterprises.
Thank you. The next one was the lady in white, or the white jacket at least.
Hi there. Laura Harrop, I'm a consultant in ethical trade and associated technology, here today predominantly representing CLT in Envirolaw. My question may have just been slightly answered, but I'll ask it anyway. It was, how can we ensure that the burden and associated cost of litigation and loss of business isn't pushed back down throughout the supply chain and essentially back onto an already impoverished labour force?
Thank you. And there was the lady in front in the grey jacket. And then that's it. We'll go back to the panel, and then we'll break for our wine and nibble. Please.
I just wanted to come back to this idea about ought to have known, and to ask you, how far do you think a brand's responsibility goes down the supply chain in terms of they ought to have known? So we talked about news articles and NGO reports, but given that most companies may not have actually traced their supply chain beyond their tier 1 suppliers, maybe tier 2, are they to be held responsible right down the chain? And if so, are we moving towards kind of mandatory traceability in the supply chain? Thank you.
Thank you. So that's three questions. I think we can ask the panel to perhaps now just make final statements, perhaps just including those three answers to those three questions were relevant to you. So we'll go in the reverse order this time. So Daniel, would you like to start?
Well, just thinking about how far companies' responsibility goes down the supply chain, I think it's very true that a lot of companies, certainly from a lot of the initial statements that we've seen, will be looking at this for the first time and won't have traceability of their supply chain. But this is, that is an essential first step of really carrying out a mapping exercise and understanding where your risks are. And I don't think companies can really address modern slavery issues until they take that step. I don't think it's going to be, perhaps not now, but as we see the statements build year on year, I don't think it's going to be acceptable from consumers, from investors, for companies to say that they simply haven't mapped that supply chain and understand where that risk is. So I would say that it does require companies to look throughout their supply chain and to prioritise where they're going to look in terms of risk by looking at geographic factors, where there's weak governance, where there's no risk factors, perhaps they have seasonal workers, perhaps there's the involvement of recruitment agencies, and to go through that exercise of actually doing that themselves. I don't think there's any easy way for companies to escape that that obligation.
Thank you very much, Kevin.
Yeah, I think you talk about tools. There are a number of tools, and say the FTSE did some research about where the high-risk industries were. But I think the most important thing is it's for industries themselves and businesses themselves to actually start to examine their supply chains and then look at areas where it's known there's high risk and where there is a lot of evidence there's high risk already. That is up to companies to do. It's their duty to do it. Just as we've heard, you know, there are very high standards about food. There's very high standards about items such as computers, such as electrical equipment, such as manufacturing of aircraft. You can tell where every bolt on an aircraft came from, but you can't tell where the staff are. So these are all achievable, but it's whether there's a desire to do it. And obviously it's my role to make sure the desire's there. But the cost, obviously, we don't want it to go down the supply chain so it makes areas even more vulnerable. And that's why I'm very clear at the moment that it shouldn't be punitive. Because actually, if it was punitive and a company saw that there was potentially an area like Bangladesh where they were closing Rana Plaza, for example, they wouldn't employ them. And those companies would become marginalised, or those countries and areas would become marginalised. Now, following Rana Plaza, some of the companies rebuilt their factories and they are giving education to the families, the children who work in the factories, the children of the parents. So there are ways of creating sustainable development, educating people, which is more than just employment opportunities. So I think if it's punitive, just like bribery and corruption, where we don't want people to engage for obvious reasons, with modern slavery, we want people to find it, and when they find it, put it right. Let's make the communities of the world and the vulnerable people have sustainable options to be able to live their lives. As for how far down should it go, I will tell you, I met with Paul Polman, the CEO of Unilever, and what does he believe about know or ought to know? He told me he wants to know where the vanilla comes from Madagascar in his supply chain. That's how far he wants to go. Of course it's going to take a long time to make sure you get down to that. But Paul Polman is a man who I would listen to about business, and if he says it, I don't think there's any excuse for anybody else to not say it. So I think we do need to have that ambition that we're going to go that far. It may take some time to get there, but your ambition has got to be what your end goal is. So I think there is a very clear line that we have to take on this if we want to address this issue in a proper way about respecting human dignity. And that may cost a few quid on the way also.
So I think Laura's question is a critical one about who's going to pay for all of these changes. I think that's a great unknown, and I think you're absolutely right. In supply chains with certain industries, the demand is so intense to keep the costs low, and so it's going to be difficult for, I think, some of these suppliers to be able to comply with that. So I think it's a very, very important question. I do think that one of the sort of results of Rana Plaza, though, for example, was there were sort of two groups of companies that were willing to pay for all of these changes and slightly raise the costs. You know, the sort of Bangladesh Fire and Safety Accord group, and then the other groups that were not willing to do that. So the companies sort of divided into separate groups. So I think that you'll see sort of a sorting of sorts of companies that are willing to sort of take these on and assume the cost of it. One thing we haven't talked about, but I think is really important that also came out of Rana Plaza is unions and the unionization. There's a huge movement in Bangladesh now for unions to try to protect these workers and make sure that they can advocate on behalf of the workers. And so we should companies should strongly promote access to unions for these companies to try to make sure that they're protected.
Thanks very much.
I think in terms of the question from the fellow from the pension fund, I mean, I think I can't give you all the tools, but I think there has been some mention of there are some tools out there. But I think what's really important is that you're actually asking the question. So that if the pension funds are actually asking the question of the companies in which they invest, well, actually, what do you do to try to eradicate modern slavery? That's a really important first step, because there's going to be lots of companies that are not really getting to grips with this and haven't actually even looked into it. So it's a fantastic first step. In terms of this, do they known or ought to have known, and how far down the chain does it go? I think there is, at present, there is a difference between what you can actually bring in terms of a civil claim based on what ought to have been known down a supply chain, and perhaps what we're talking about in terms of where things should go, in terms of the statements that are being encouraged to be declared. But I think that gets back to this issue about litigation actually being only one of several tools, and so the fact that you've got some litigation which will rest very heavily on what was known or ought to have been known by a company is one aspect of it. There are limits to that. In terms of the legislation that requires companies to at the very least report on what is happening in terms of modern slavery in their supply chains, or what they're not doing, or why they're not going to report on it. I mean, that is at least one aspect of just trying to ensure that there is looking down through the supply chain all the way to the end to say, well, actually, we do know this now. And then another aspect of this sort of toolkit is actually to do with things such as pension funds and investors actually asking those questions, which are not necessarily based on whether or not there is a legislative or legal requirement to know, but is actually then based on, well, what are the risks if I don't know? So what are the risks in terms of those who invest in me? What are the risks to my reputation? What are the risks potentially to my consumer base? So, you know, there are all those other aspects that are quite important to what should or what ought to have been known. And in terms of the costs of litigation being pushed down the labour chain, I mean, I don't think it's such a binary scenario that it's either the consumer or it's the person who is actually the producer of various goods that has to bear that brunt. I think we should more critically look at the companies that are making the very large profits on both sides of that equation, and actually there should be an obvious potential for companies to have to perhaps squeeze down a little bit in terms of their profits and not impact the person who is the most vulnerable in that supply chain scenario.
Let me just a couple of comments. The pension funds, it's a really difficult issue right now. There aren't the tools that you need, but it's changing very quickly. It really is. And in fact, you know, this kind of legislation regulation is creating a market that for-profit firms see as an opportunity to make a profit. Thomson Reuters is spending a lot of time and money looking at how they provide the information that companies, including pension funds, and they've announced it publicly. Palantir, a huge US company, is spending a lot of time looking at how they can assess risks in terms of, you know, types of industry and regions. SAP, these are all big, all the big accountancy firms are getting into this space because they actually see a market. So I suspect in 2 or 3 years we're going to see a major change in the availability of tools and knowledge. And on the impoverishment of the labour force, you know, the big attitude change, one of the big attitude changes is I think that we need to help educate consumers. We will have to pay more. We can't have $2 t-shirts and then wonder why there is exploitation in you know, cotton supply chains all the way to forced labour in Uzbekistan and garment mills in India. You know, we can't buy super cheap prawns and not wonder why we can afford to get this so cheaply. And when I go out to Thailand and meet Burmese fishermen who have been enslaved on fishing boats and see people who have been enslaved in fishing sheds, you know, there is a cost. But it's a cost that, you know, I think as a society we have to accept that we need to pay, and it's not that different. Let me finish where I started. You know, the kind of the abolitionist movement was talking about cost of sugar. It was talking about the fact that consumers will have to pay more if we don't want to have people that are enslaved producing goods to reduce costs beyond an acceptable level. We deal with this in terms of environmental costs. We now have to start dealing it with labour costs, and I think that's part of the attitude change that we need to bring about. Litigation will be part of that, but it will be all of these other issues that we all need to be part of a movement that changes awareness and willingness to accept that there are trade-offs.
Thanks very much. I hope you will join me, first of all, in thanking the panel for the extraordinary. I now stand between you and the drinks, so I'm going to be very brief, but I do hope that we've all heard, you know, that there are extraordinarily complex global value chains now, and that there are villains and psychopaths that will exploit those value chains in order to insert modern slavery within it, with the extraordinary, extreme exploitation that involves. The strategic litigation is one of the key tools, but it's one of the tools amongst the many powerful tools that we will have to bring together in order for this to really work. There'll be voluntary, there'll be legal, there'll be all sorts of different ways in which we have to bring this in order to, as one of the panelists said, increase the costs so this becomes a high risk, a no-profit approach. There is going to be litigation, as we've heard. There's going to be litigation around Congo, around Qatar, around Thailand, but there's also litigation around Dewsbury in West Yorkshire, where I come from. So it's going to be also that universal movement that Wilberforce and others promoted. It's going to involve also workers' organisations being involved. We're going to need those corporate leaders, the corporate leaders that are going to show that it can be done through their complex supply chains, people like Paul Pullman. We're going to need also governments, people like Kevin, who are prepared to stand out and increase the cost because of the increasing level of cases that are going to be brought before the police. We're going to need extraordinarily courageous victims, people who've been brutalised so much that to stand up against the perpetrators is an extraordinarily brave thing to do, and lawyers to back them up. We're going to need those investigative journalists who will take risks to be able to reveal this. And we're going to need also all of us involved in raising that public awareness that in the end is the only way in which we're going to really move this in the kind of, with the ambition that we all have. So there's many opportunities for us to really collaborate on this issue over the coming perhaps 5 years, in the same way again that Wilberforce and the whole movement brought that together 150 years ago. I'll finish just by saying a huge thanks to Notre Dame. Firstly to Sinead, who's been extraordinarily helpful in organising all this, but also to Roger, who's also played a fundamental role, and to our absent friend Doug Cassell, who's the instigator with us of this series which began 3 years ago. And finished with my own colleagues who've played an extraordinary role, particularly Mauricio, who's led on all this work and the development of the ideas with Roger and Doug, but also to Danielle, who's played a role in the organisation, and also to Alex and the rest of the team. So with that, thank you very much, everybody. There's drinks at the back.